superior durability, superior hiding, superior coverage, simply superior.
Sasso insecticide spray and coil. Kumintuntum Prekun.
Hello, good evening, welcome. This is Ghana Tonight. We're live from our news about Desawe Kanda, also live on TV3 Ghana on Facebook and on DSTV channel 279. We're all across the world on 3news.com. I am Alfred Akonse. Tonight, the United Nations vote on slavery reparative justice sparks heated debate with criticisms directed at countries that voted against the motion or abstained. Well, we'll hear from those who have this position as this matter continues to occupy some space in the lips, on the lips of people. Ghana School of Law, popularly known as Makola, loses monopoly over professional legal training as Parliament passes legal education reform bill into law. We'll tell you what exactly this development means. We'll have one of the members of Parliament who promoted this particular bill, led it on the floor of Parliament, and what happens after today. Stay with us. We'll have a conversation. Tonight, the minority in Parliament prepares to petition the Commission for Human Rights and Administrative Justice, CHRAJ, over President Mahama's use of his brother's private jets, amongst other matters, which they say violates the law of conflict of interest. Stay with us. We have this and more, as always, you're an integral part of the conversation. The hashtag we're using is Ghana Tonight on Facebook and on X. Let's get talking. Let's start off with Ghana Briefs.
General Secretary of the Socialist Forum, Kwesi Pratt Jr., has criticized some countries, including Israel, for failing to support Africa in recent votes on reparations for slavery. He described their position as unfair and urged African nations to reassess their diplomatic and economic relations with such countries. He made the remarks following a vote in which 123 countries backed Africa's call for reparations over the historical injustices of slavery.
It's the gravest crime against humanity ever committed. That's a significant moment in our history. And we who have gathered here today ought to understand the full implication of that declaration in the UN General Assembly yesterday. One thing is clear, the lines were clearly drawn between those who carried out that inhuman trade, who profited from it, whose institutions continue to be built.
Renowned international artist Ibrahim Mahama has renewed his call for justice following an alleged assault by a group of police officers. Mahama appeared at the police headquarters in Accra at the invitation of the Police Management Board to provide his account of the incident. Speaking to journalists afterward, he emphasized the need for a thorough investigation and urged authorities to ensure that justice is served.
We just want justice. That's it. It's just that, these things, they take a while. I've been going to the dentist, drilling, there's teeth reconstruction and other things happening. Yes. So, internally we don't have an MRI scan. So now that I'm in Accra, I also have to follow up and do a scan again, things like that. So setting the point is that when things like this happen, the question is that how do we make sure that it does not repeat itself? As I said before, none of us have any problem against the Ghana Police Service. The Ghana Police Service have been very kind to us.
The Accra High Court has set April 2 to rule on an application to halt the hearing of Wontomi's illegal mining case pending the hearing and determination of a request at the Court of Appeal. Lawyers of the NPP Ashanti Regional Chairman Bernard Busiako, also known as Chairman Wontomi, have filed an interlocutory appeal against the dismissal of their submission of no case at the High Court. Andy Apiakubi is lawyer for Chairman Wontumi.
A criminal trial of this nature, if there is an appeal against a decision that can bring the proceeding to an end, it is only natural that one must think of handling the appeal and seeing to the results of the appeal before we proceed.
The minority in parliament has accused the government of what it describes as a potential state's capture involving President John Mahama and his brother Ibrahim Mahama. Addressing the media in parliament, the ranking member on the Lands and Natural Resources Committee, an MP for Asante Mampong, Kweku Ampretrum Sapong, raised concerns over the president's use of a private jet owned by his brother for official state travels.
Ghana is watching two things happen at once. It is watching the Damai gold mine being arranged for the president's brother. And it is watching that the same brother's private jet carried the president on official state visits, free of charge, we are told, while his companies accumulate hundreds of millions of dollars in state-linked contracts.
Black Stars head coach Otuado has expressed strong confidence in the squad's readiness ahead of their high-profile international friendly against Austria on Friday. Speaking at a pre-match press conference in Vienna, Ado emphasized that the technical team has conducted an exhaustive tactical breakdown of the Austrian side to ensure the Black Stars are not caught off guard by their opponent's aggressive playing style.
The first question is, I think, in now modern days football, to be honest, everyone can beat everyone. I'm very, very sure. And I think we saw it at the last World Cup that there's no team to be underrated. And surely Germany is a high profile, but to be honest, I'm not thinking about Germany now. So for us, it's the full focus on Austria. We want to win every match we play. This is for sure.
There's more news on 3news.com. Make some time and visit 3news.com. This is Ghana Tonight. We're live on 3FM 92.7. Also on TV3 Ghana on Facebook and on DSTV channel 279 all across the world on 3news.com. We're also on 3 News on YouTube. As always, proudly brought to you by Flamingo Paint, Simply Superior, Sasso Insecticide Spray and Call Tom Preco. Coming up next year on Ghana Tonight. The minority in Parliament. They have been raising concerns over President John Mahama's use of his brother's private jet, and they say elsewhere that with the company that's owned by his brother, businessman Ibrahim Mahama, engineers and planners, being strongly considered as one company bidding to take over the Daman mines, they say it smacks of conflict of interest. This is not the first time they've raised this particular issue. The first time they did, we've seen a number of things happen where we've had some other companies as well that have been reported to have been interested in this particular mine under consideration. But the minority in Parliament earlier today accused the government of what it described as a potential state capture involving President John Mahama and his brother Ibrahim Mahama. Addressing the media in Parliament earlier today, the ranking member on the Lands and Natural Resources Committee of Parliament, he's also the member of Parliament for the Asante Mampong constituency, Kweku Ampretrum Sapong, is raising concerns over the president's use of a private jet owned by his brother for official state travels. This matter keeps coming up again, but this is what the minority said. Take a look.
Ghana is watching two things happen at once. It is watching the Damai gold mine being arranged for the president's brother. And it is watching that the same brother's private jet carried the president on official state visits, free of charge, we are told, while his companies accumulate hundreds of millions of dollars in state-linked contracts. These are not separate stories. They are the same story. They share an author, a beneficiary, and a constitutional problem. Taken together, they present the most serious conflict of interest question to confront any Ghanaian presidency since the Republic was born.
Well, the minority is also demanding what they describe as a transparency in all matters, including the Damang Mines issue that they have been talking about.
We call for the immediate publication of the full bidding documentation, including the date of formal tender initiation, the criteria, the tender committee's composition, and the evaluation methodology, in compliance with LI 2176. 2, compulsory disclosure of the full beneficial ownership of all trade bidding entities, including EMP connections, with compliance with Ghana's EITI corrective action obligations, because we are beginning to smell a rat.
Well, so that's the minority. The Adam Sarano is the co-chair of the Citizens Movement Against Corruption, and he has been also rendering his service as chair of the African Union. That's the group that has been set together or put together by the African Union to also champion the fight against corruption on the continent. Sarano, good evening. Thank you for joining us.
And thank you for having me.
Now, the minority says they are smelling a rat. In these instances, they talk about with Ibrahim Mahama, the use of his private jet by the president, and then also the Damang Mines that his company, engineers and planners, are being strongly considered for. I mean, do you smell a rat as well in there?
No.
Why?
I don't smell, nor do I see any rat. I think it's a bit far-fetched. I mean, conflict of interest is a very clearly spelled out concept. It's a situation where your personal interests compromise your public function or decision-making, until and unless they are able to specifically state which public function has been compromised by a particular personal interest. We are just speculating, and I think it's a very dangerous and slippery slope they are taking. I can't fathom the connection between the two issues. The first thing to establish is this an actual conflict of interest, potential conflict of interest, or apparent? If it's apparent, well, they are within their rights to say there's an apparent, but they need to specify what constitutes that apparent conflict of interest. Trying to weaponize conflict of interest where it is something where you can easily recuse yourself or declare your interest and it is dealt with, seems to suggest a lack of full appreciation of the conflict of interest concept. And I think that the relationship between that and a Damang mine, whatever, is tenuous at best. I'm not quite sure where they are headed to on that trajectory.
As if you describe it as tenuous, but they reference a particular provision in the Constitution, and I'm going to put it on the screen right now, Article 284 of the 1922 Constitution of the Republic of Ghana. That's the foundation of the minorities' demand and the claim, and their decision to now go to the Commission for Human Rights and Administrative Justice, CHRAJ, to ask CHRAJ to look into this matter and ask some questions. They say a public officer shall not put himself in a position where his personal interest conflicts or is likely to conflict with the performance of the functions of his office. Does this give some locus?
Alfred, it's still tenuous. This is just it's a high-level use of language. Listen, what public function does the president of this country have in respect of the contract or the bidding relating to the Damang mine? What role does he play as the president of this country? Does he have a direct function? A direct function that his personal interest will impair or compromise in respect of the mine? Isn't there a properly constituted committee that is supposed to evaluate? Isn't there supposed to be an opening of the tender documents to decide who bid what, etc., etc.? And the processes defined in such a way that at that level, which has nothing to do with the presidency, a decision is taken. And the causes or opportunities for if somebody is dissatisfied and thinks that something untoward has happened for them to then, raise those issues. It is tenuous. I mean, throwing in that he's a strong contender or strongly being considered, where is the evidence? Where are the facts? So, and this is what the politicians do. They come and they say things. Next time when they're in those shoes, then they have difficulty because the way they applied it or interpreted it did not make sense. So they should be cautious. It's a slippery slope. They need to demonstrate to us what specific public function of the president is being impaired or compromised by a personal interest. But at best, at the moment, we say they are talking about an apparent conflict of interest.
And it is on that particular point that you acknowledge that the conflict of interest is in 3 levels.
Yes,
it could be apparent, it could be real, or it could be perceived. Right?
Yeah.
To the extent that you've actually find these 3 levels of conflict of interest being reflected in the constitutional provision that I just read, and we're going to put that back on the screen, and let's make sense of the interlinkage or the action I'm talking about, that a public officer shall not put himself in a position where he is
Which position has the president put himself in? I mean, you can't answer that question. They haven't answered that question. You are saying he should not put himself in the position. Is the president bound to take a decision related to the Mang Mine personally? That's the question I'm saying. There is no direct linkage between the president and the decisions that have to do with the tendering of the Damang mine. He's not part of the committee. So what decision, public function is being compromised? There's no such connection. Unless you're trying to say that the president is the one who is reviewing the documentation, who is going to do the screening and the weighting in terms of the marks, the ratings, and then deciding and then writing the report. Come on, let's get real.
They point to certain individuals who had employment history with Ibrahim Mohammed's company, who have been employed at the Minerals Commission now. They said it at that press conference as well.
Come on, are those people on the committee? They are saying they were linked with Ibrahim Mahama. They are saying, have we done the background checks to the due diligence to say that is true? But beyond that, the material issue is this. Are those people part of the committee that is assessing this? Who constitutes that committee? Are they suggesting that these persons' objectivity is being impaired? And to that extent, therefore, shouldn't we therefore say that then those persons should recuse themselves from the committee if they are on the committee? Let's have a direct linkage between the facts and what they are saying. But to then extrapolate it and then say that the president is a conflict, and you are weaponizing conflict of interest. Interest doesn't automatically mean that a crime has been committed. The fact that there's an apparent conflict of interest doesn't mean that in actual fact a crime has been committed. Let alone potential conflict of interest.
To the extent that now you see it as an apparent conflict of interest. That's the level that you analyze this.
The only level we can begin to say is apparent. And apparent means that it is not necessarily real. And I'm saying that from where I sit, it does not seem real at all.
But that's why now they are going to CHRAJ, to ask CHRAJ to now lift it to the next level of being apparent to
so if they are speculating,
that.
They should just say they are speculating and they want CHRAJ to do the investigation and see whether there are any actual facts. It means they don't have any actual facts, because they've not actually laid out any facts that show the connection between the president and a particular decision.
What about the issue they raised with the usage of the private jet that belongs to Ibrahim Mahama?
Again, it's speculative. What facts have they raised to show that the president's public decision-making has been compromised by his personal interest? I mean, look, throughout history, we've had situations where I think President Kufuor appointed his brother as a defense minister. I'm sure there were contracts that were handled. Did we find, and his brother was a doctor, by the way, he wasn't a defense expert. Did we automatically see that as a conflict of interest? I mean, we need to be cautious how we start doing interpretation on these issues. So what exactly are we talking about here? That the president feels he's more safe using his brother's plane. That plane, is he paying money to his brother who should not be paid? Is it above an expected rate?
Well,
is it at a subsidized rate?
The only cost we understand the state is bearing, based on what Phyllis Kwachofosu, the Minister in charge of Government Communications, has indicated in an earlier interview, which we're going to recall. He says the only cost is the fueling of the flight, or that's the jet,
which means
and then
that
also I'm coming. There's another second layer of the charges is the landing rights and other related costs that have to be paid. So those are at least the categories of the cost that we know.
Now, that then tells you something. Go and do a comparison with if we're renting or hiring a plane. Were we likely to pay more? Is it therefore at an extra cost to the state or not? Is that a decision that has been compromised? Does it make logical sense? Has the president taken a decision that has, as it were, undermined the best interests of the state? I mean, unless you can show that the fuel cost plus the landing cost is much more than what would have happened if, in the absence of a plane, he had to hire a plane, etc. We still are hanging on strings, spider webs. So until they can say a specific public function or decision has been compromised, you can demonstrate it with facts and figures, I think this is going nowhere, and the politicians should stop thinking that we cannot read through these things. And then next time when they come, when is their turn and they appoint a brother or something? And by the way, the fact that the president has a brother should not stop the brother if he has legitimate expertise to offer in various sectors of our economy from doing so. Especially if he is the best, his business has the best option. We should not begin to tie things that have no laws that stop that. There's no law that has been breached. No policy has been breached. So let's not create a fuss where there's really nothing.
I see. So now, from your standpoint as an anti-corruption person, the decision beyond just raising concerns about the minority's position, now they want to go to CHRAJ. They say they are considering that idea together with other CSOs to invoke the powers and the presence of CHRAJ in this matter, so as to bring clarity and some level of finality to it. Is it one that you support?
Yes, it's commendable. I mean, using the institutions of state that have capacity and expertise to give them some feedback, I think is the best way to go. And CHRAJ does have the expertise as far as it comes to issues of human rights, administrative justice, as well as the issue of conflict of interest. They're able to establish whether there is a potential conflict of interest that has arisen, or there's an actual conflict of interest, and whether any of these two actually infringe on any laws, and therefore there's something that the president should be held up against. And I'm sure they'll take into context all the other similar scenarios that have happened historically, whether we should really be going down this route.
Manzano, thank you very much for your time. Truly appreciate it as always.
And thank you for having me.
Adam Manzano is the co-chair of the Citizens Movement Against Corruption. But let's just recall this matter of why the president's use of the private jet belonging to his brother. This is not the first time the minority has raised this concern. Phyllis Kwachofosu is a member of parliament for the Abrasebo Kwamankese constituency, and also the minister in charge of government communications has been explaining, giving details of exactly the cost that the state bears when the president uses this private jet and why the president is using the private jet in the first place. Take a look.
The Ghana Air Force itself has made it known to government officially, through official communication, that given the frequent breakdown of the presidential jets and its unreliability and the problems it poses for operational efficiency, they would much prefer that government acquires a new presidential jet together with other equipment for the Air Force. Now, government heeded our advice and put before Parliament an agreement to procure the third jet Parliament approved, and the process has begun for the procurement of that jet together with other aircraft. Indeed, only recently the first helicopter in that series of purchases arrived. But in between the time that the agreement was approved and the time that the aircraft will arrive, there's a need for the president to travel. So the president simply thought that rather than spend the taxpayers' money renting aircraft, he has a brother who has an aircraft that he had been using even when he was in opposition. That aircraft is available, and beyond fueling it and other charges, which do not necessitate paying for its rental, it is fit for purpose and it can be used. Indeed, the present aircraft is new, and everybody has seen that it belongs to the president's brother. The president's brother is a well-known businessman who started his business long before the president came to power. And therefore, if that aircraft is available and it will not cost the taxpayer tens of thousands of dollars an hour to rent it, the president thinks that it is a prudent thing to use as he waits for the more permanent solution of the new aircraft. So that is really what it is. He uses it for free, beyond paying for. Well, I've answered this question many, many times, and I believe you even interviewed me on it. So I'm surprised that you keep on asking when the answers have already been provided. The president does not rent that aircraft, so there's no need to pay for its rental beyond fueling it and charges that may accrue due to landing rights and all that. That is about it. If the president rents an aircraft, he would have to pay for the rental, like President Akufo-Addo was doing when at some point he was paying $18,000 an hour to rent this aircraft. And you see, the president's travel schedule are such that there are times when he has to make different hops in different countries. So he can travel to about 3-4 countries on the trip.
That's Phyllis Kwachofo, so in an earlier interview responding to this matter that this is, we had this talked about quite a number of times since the president's decision to use this private jet belonging to Ibrahim Mahama. Well, the minority has indicated they are going to CHRAJ on this matter together with the CSOs, other CSOs who are backing this move. So it's one that we'll keep an eye on and we'll be updating you as and when they eventually go to CHRAJ on this matter. But coming up next on Ghana Tonight, still on the matters of law, the Ghana School of Law loses its monopoly as Parliament passes legal education reform, and what happens after today. So that's going to be the major part of the conversation as we're going to have it. But earlier today, Parliament passed the legal education reform bill, paving the way for major changes in how lawyers are trained in Ghana. The new law seeks to decentralize professional legal education by abolishing the entrance examination for admission into the Ghana School of Law. Mahamadou Shaibu is the chair of the Constitutional, Legal and Parliamentary Affairs Committee of Parliament, the committee that worked on this particular bill, which has been passed by Parliament earlier today. He's been speaking to us on it. Take a look.
There are many institutions. Every district assembly should have a lawyer. Every ministry should have a lawyer. You see, because there are many issues about procurement at the district level that you need legal advice in terms of how to go about it. So to say that there are too many lawyers, I've never been part of that. We really don't have the lawyers. A ratio of 6,900 to 1 lawyer is woefully inadequate. People study law to do legislation, and so you find them here doing legislation. People study law to do corporate practice. People study law to do many other things. And so the fact that those in courtroom practice are not enough does not make it. If you take University of Ghana, who already run faculties, I mean, they have the capacity. The existing Makwala is still there. It's still part of the institutions that will be training the professionals. So those institutions are already there. Kwame Nkrumah University of Science and Technology has run this program for some time. GIMPA has done that, and then the rest of that. So there is this institution that already even have the capacity. All we need to do is just let them match up to the additional requirements that the law envisages. And so once they get that, And that's why we are saying that the existing institutions that already have the capacity should be able to absorb the backlog of LLB students who are in the system. And then as the years go by and we produce more, they will be able to absorb all of that.
Well, so that's the chair of the Parliamentary Select Committee, that's Legal and Parliamentary Affairs Committee of Parliament, that worked on this particular bill. And this is coming at a time when there's been a lot of interest in this bill for good reason, because of the objective of the bill in decentralizing legal education so as to ensure that there are more lawyers that are produced in the country. You heard him reference the ratio of the population to lawyer, one lawyer to 6,900, almost 7,000 population is one that he raises concerns about, which was actually one of the reasons why this bill that has been passed into law, this legal education reforms bill, which is now law, that has been approved by Parliament, as a matter of fact, is one that was the major concern for those who proposed and sponsored this bill. One of them is going to be joining us in the studio shortly. Nelson Roxon Dafempo is Majority Chief Whip and a Member of Parliament for the South Dai constituency, and one of the sponsors of this legal reforms bill, which has been approved and passed by Parliament. What you see on the screen is what existed until today, where you have a number of faculties, law faculties in the universities that are offering LLB as a course. So if you go to, for instance, the University of Ghana or UPSC, Wisconsin, all the others, University of Cape Coast, KNUST, they have law faculties in there. So what you see numbered between 1 and 15 down there, we just put a number, an estimate to the number of universities running these law faculties. Now, what you see there between the 1 to 14 are these universities running or offering law, that's a LLB, in their various faculties. The 15 is those who studied or read LLB outside of Ghana and are called to the bar outside of Ghana, but then come into the country and want to practice law in Ghana. So you have people who would go and study or read law in Gambia or in the UK or in the US. They come back to Ghana, they want to practice law in Ghana. They would have to go through the Ghana School of Law. That's what they call the post-call. So that makes up what existed until these legal reforms that we're seeing. When all these people are done with either the 4 years of LLB or 3 years, that is for the post-first degree LLB students, then you sit for an entrance exam to go to the Ghana School of Law. At that point, a number of people are cut off. So depending on the capacity that the Ghana School of Law, that's Makola, can take, that informs how many students who have completed LLB at these various faculties, and even the post-call people, would enter the Ghana School of Law. Now, what is going to happen after this law that has been passed by Parliament is these faculties that previously were just preparing students after LLB for their entrance into the Ghana School of Law, some of the faculties that have the resources, they have the faculty, and then they have also the various capacities that is needed. For instance, the research capacity, also the well-equipped library and so on. They look at all of that, and we'll have to find some more details. Nelson Roxon Dafempo is just joining me in the studio right now, so he's going to be taking his seat in a bit, so we get a clear understanding of what we are going to be faced with in the coming days after today. But this is how the picture looks like. I'm going to put it on the screen right now. Now, after this, the Ghana School of Law will not only be the institution that is offering the professional law program. Other law faculties would now be accredited to offer this professional law program. And the selection of these law faculties to be accredited to now offer these professional law programs would be determined by some sort of a criteria, which we would have to get to find out. And when is this going to take effect after this law has been passed? We need all of that detail. And then that will also give us an idea of what the next stage will be. The Minister in charge of Justice and Attorney General, Dr. Dominic Akuritinge Ayene, explained on the floor of Parliament some bit of detail on what the next steps will be. Take a listen to him. We'll come back in studio. Nelson Roxin is joining me right now in the studio for some more on this. Take a look.
The example I gave yesterday was just to say that the fact that you have passed the law practice course in and of itself is not a basis for saying that you must automatically be enrolled. So there are other criteria that are taken into account. And the honorable member for Okwankwe Central has just pointed out that we have a legal regime for that already in existence. Mr. Speaker, if you remember the case of is it Ama Governor? Amagana. Yeah, Ama Governor. I said I was right. So if you remember the case of Ama Governor, all right, she passed her exams, excellently. But the General Legal Council took a decision not to call her to the bar, not to enroll her onto the role of lawyers, just because of certain social media, videos that they saw that they thought were below par in terms of moral turpitude, and so they refused to call her to the bar, and she had to, as the chief whip has said, she had to go to court to compel the General Legal Council to call her to the bar. So, Mr. Speaker, I don't think that this is something that we have to legislate here, particularly in light of the fact that if we say of high moral character, as it is stated in Article 94 of the Constitution in relation to us, then you might have to necessarily define what you mean. And I don't think that we can.
The Attorney General and Minister of Justice, Dr. Dominic Akuritinge Ayene there. Joining me in the studio is Member of Parliament for the South Dyke constituency. He's a Majority Chief Whip in this night Parliament, Nelson Roxin, also one of the sponsors of this legal education reform bill that has been approved by Parliament today. Honorable, good evening. Thank you for joining us.
Thank you very much. Good evening to our viewers. And let me use this opportunity to say congratulations to all of us for this momentous bill that seeks generally to transform the legal sphere as we know it. If you recall, it's not been an easy journey.
True.
Yes, it was a very difficult fight. When I actually began this advocacy about 10 years ago.
I see.
You've
been on this for the past almost 10 years.
Yes. And so, but today we are here. And let me also mention my colleague, Dr. Susu, because it got to a time in Parliament, during the 8th Parliament, we actually came together to submit a private member's bill. But of course, we were frustrated too. He didn't see the light of day. But
you're talking about the Medina Member of Parliament.
Yes.
Dr. Francis Xavier Susu. But there are key questions I want to find out. So what happens to the Ghana School of Law, the Makola as we know it?
Okay, so Makola has been re-established as it were under this new law as an institution that is to provide the legal education in terms of the professional training. Now, in addition to Makola as we know it, my alma mater, other accredited faculties or universities. Because we have defined in the law, we have defined universities to include institutions, any institution accredited to offer the legal training and the professional training.
I see.
So other accredited universities that will be accredited to provide legal education, leading to the writing of the national bar exams.
Right. But who gets to go to Makola now, the Ghana School of Law, the Makola under the new law?
If you are in possession of an LLB, you could apply to Makola to be trained at Makola at the professional level for 1 year.
Without
they will
any
examine
exam.
you.
Okay.
They will examine you and issue you with a certificate. Okay. And then that will make you eligible to sit for the national bar exams.
So would you need to write an entrance exam to
No.
the Makola?
The era of entrance exams is gone. Everything is gone.
I see.
Yeah.
So, for instance, if you have...
But if the universities decide to introduce an entrance exam for the intake, that is from level 100 to enter level 100, if they decide to introduce an entrance exam, that is purely their business.
I see.
But once you enter, it will be the level of the different stages of assessment will not be an entrance exam.
Right.
So to pass to progress from level 100 to 200, there must be an assessment.
That's the end of semester
system. So 200 to 300 assessment.
300 to 400.
But we have also shortened that period to 3 years.
Okay, so what that effectively means is that now, if you are going through the system, you would have been called to the bar after 6 years. So then you do 4 years LLB. That is, you are doing the mainstream.
Yeah.
You do 4 years LLB and 2 years Makola. That's 6 years. So what does this bill do if you say you've shortened the period?
So now
that's for the mainstream.
you train for the LLB, you do 3 years LLB.
3 years LLB.
And then you do 1 year professional training.
That's even for the mainstream?
Yes, even for the mainstream.
So how about the post-first degree LLB?
Yes, so I did post first degree LLB in 2 years. In fact, our time, I did it for 2 years.
You that was for 2 years?
Yes.
And then you did Makola 2 years?
Yes.
And so 4 years?
So 4 years.
So is that what we are returning to?
Yes, so if cumulatively that will be 4 years. But because the LLB, the new curricula will entail a bit more. So the LLB duration is 3. Then you use 1 year to train professionally. You'll be examined, issued with a certificate. Then you are eligible to be presented by your university to sit for the national bar exams.
Right.
To be conducted by the National Bar Examinations Committee, which has also been set up under the Act.
So the students who are already in the system, what happens to them?
So there were very interesting scenarios today. So that's the transitional provision. So the transitional provision has made accommodation for them. So those who are at the professional level now, they wouldn't have to sit for any national bar exams.
So those who are at Makola now?
Now, yes.
The year 1, year 2?
Year 1, year 2. They will progress under the existing law.
Okay.
Under the existing law.
Okay.
But those who are at the academic level, which is the LLB level, your institution gets accredited.
Okay. Yeah. So I'm going to go for this quick break when I come, because I'm going to interrogate a bit more on that particular, on the students who are already in the system. So, for instance, if you're, say, level 300, what happens? Because you're saying that this is going to reduce.
If you pass your final exams, you'll be issued with your LLB certificate.
No, so I'm talking about those who are in level 300 now.
Yes.
So it means they are not going to go to level 400 after?
No, so the change will affect, so the curriculum will be redesigned.
To affect those who are in the system?
Yes, will be redesigned, So in redesigning the curricula, there will be rearrangement. So I am just telling you that I obtained the LLB in 2 years.
That's right.
In 2 years. So what may happen is that they are going to, the universities are likely to increase the credit hours.
Right.
The number of courses you take in a semester. For instance, if you are taking 6 courses in a semester, I suspect, because we haven't gotten to that stage, we are in the frameworks available, I haven't seen it yet. But I suspect that the universities will be responding to the new regime. And in responding to the new regime, which of course will also affect the timelines that a lot of them are using now. So the courses, the number of courses, if you take 6 courses in a semester, they may be compelled to do it 7.
Right.
Okay, so that you can take the required number of courses within 3 years to be able to be awarded the LLB, for instance.
I see. Now, let's stay on this because I'm going to go for this quick break. When I come back, we'll get some more details on this matter. It's important. Stay with us. Welcome back. This is Ghana Tonight, and we're live on 3FM 92.7. Quite a number of you interested in this subject. We've got so many of your messages. We'll try to do the best we can to get some responses to it. Nelson Rosin Dafempo is still with me in the studio. He is one of the major campaigners of this bill, this legal education reforms bill that has been passed by Parliament today. But maybe before we get into the issues of what's going to happen to the students, what happens after today that this bill has been passed by you?
Yes, in pursuance of our new standing orders, when bills are considered at the consideration stage and taken through the third reading, hitherto Parliament had very little role in reviewing what had been eventually enacted, sort of put together. Mm-hmm. But in pursuance of our new standing orders, it's a requirement that the final draft, as agreed to, or subject to the various amendments agreed to and carried on the floor, mm-hmm. feature in provisions that they were carried and adopted, mm-hmm. or rejected. So Parliament's duty is to review the final draft before the clerk would transmit same to the office of His Excellency the President for its assent.
Right.
So as we speak, there's an enormous pressure. You see that it's nearly 11 p.m. and I just arrived from Parliament.
Indeed.
I haven't gotten home yet. So we are getting the drafters in Parliament to put the final draft together, because by August this have to move into full swing. By August.
By August.
Yes.
This reforms will have kick in.
Yes.
So how about those who have completed their LLB and are home preparing for the Makola entrance exam in October?
So there will no longer be any preparation for any entrance exams.
This October?
Yes.
They will not.
No. So there's no October entrance exam for anybody with an LLB. What you should be preparing for is to be identifying which of the yet to be accredited universities of your choice that you would love to pursue your professional training and apply.
I see. And which institutions are going to be accredited for this?
We have about 14 faculties.
Yes.
Law faculties, yes. Now, both private and public. So the law there is freedom of choice. If the law is assented to by His Excellency the President, it comes into effect. Mm-hmm. We have mandated the Attorney General to, within 12 months, come with regulations to give effect to it. Mm-hmm. But the terms of the law will kick in. So the Board for Legal Education will set up some requirements or checklist standards for the universities to meet for purposes of accreditation.
Some sort of the criteria?
Yes, so it will be a checklist. So you have to tick the boxes.
Those boxes.
And the law, we made those prescriptions in the law.
Okay.
For instance, if you have a library, it must be a library of some size, some volume, books, all those things we've put them in the law.
Faculty experience,
yes,
faculty,
and all that. Even your teaching faculty, there must be people of, I think, minimum PhD. Minimum PhD. So the universities will have to go into an overdrive to be able to prepare themselves for takeoff, for accreditation and takeoff.
I see.
So what I suspect will happen, if it hasn't happened already, because they were fully involved, is what we call the Conference of Law Deans. That is the deans of
the various faculties.
They have a conference, and because they participated in the enactment of this bill, the preparation, and eventually taken through Parliament and enacted today, they have followed closely, and they know what they are supposed to do to meet the standardization for accreditation. So they will put their house in order, so to speak. I don't want to bore people with language. They'll have to put their house in order to be ready to be accredited, so they can take off with the new system.
I see. Earlier, you had indicated that this bill that has been passed now effectively reduces for those who, under the current regime, were doing 4 years LLB.
Yeah.
They will reduce it to 3 years LLB, right? And then they will do the 1 year professional,
yes,
which now makes it 4 years.
Yes.
But then for the post first degree LLB, if you are just starting, let's say in September, it would now be what, 2 years?
It will depend on the checklist,
okay,
the curriculum, because you see, there is going to be a change, some dramatic change in curriculum design,
okay,
which will be championed by the Conference of the Law Deans.
Right.
Okay, but it will be in consonance with the new regime.
Okay.
So, because we have advocated that courses like taxation should be taken to the LLB level. Courses like company law should be taken to the LLB level. Courses like evidence can be taken to the LLB level. Because evidence really can be studied at the LLB level. So we leave the civil procedure, the criminal procedure, the advocacy, the other things, maybe other things that make, like conveyancing, drafting, those ones, yes, for purposes of the apprenticeship,
okay,
in the law.
Right.
We leave those at the professional training level. Because that is the preparatory stage to making you a practitioner at the bar.
I see. And just to also clarify, before we went for the break, I asked about the students who are already in the system, so that, for instance, the post-first degree LLB students.
So my brief answer to that is that when the curriculum is reformatted.
What's the timeline for the reformation or the review of the curriculum to now fit into this new bill?
It depends on how prepared a particular university is. Some may be more prepared than the others. You understand? But who will set out the criteria for the reformation of the curriculum?
Okay.
So if you do, then you are ready to be accredited.
And it's
so that when that happens, a student who is at level 200 now maybe under the circumstances take more courses per semester. If you are doing 6 courses per semester, you may, given the circumstances, be taking like 7 or 8.
Right.
So that you can accrue the number of minimum credit hours. That is the minimum requirement for the award of the LLB degree.
Which effectively reduces the number of years.
Yes.
So now, the post-first degree LLB, now the current system is 3 years.
Yes.
So if the curriculum is reviewed, then it would reduce it to 2 years.
Yes.
If you are
yes. So if you are entering with a first degree, then the university will set the criteria in such a way that you enter at, say, level 300.
Okay.
And that was what the University of Ghana did for me. When we were entering in 2005, I believe, we entered at level 200, at level 300.
Okay. Finally.
So 300, 400, we obtained the LLB and we entered Makola.
Finally, if your faculty or if the faculty of an LLB student who's watching us is not accredited because they don't tick the boxes, and then they complete the LLB, what happens to them?
Now, accreditation will be, so that student will have to apply to an accredited university and must satisfy that university that they meet the standards in obtaining the LLB, for which they have to be admitted to pursue the professional training in that university. So you are bringing an LLB from a university that is not accredited, but is accredited under the present existing law to train people to obtain the LLB in the academia.
Right.
Because the LLB is an academic degree.
Sure.
You understand?
Okay.
So they will have to look at the curriculum of that university and determine that you've met the minimum requirement for number of compulsory courses.
Would they have to write some exam of a sort?
No, but I don't think exam writing will be necessary.
Okay.
It's just certain, because you are bringing your LLB from another university. So once it's a university of analogous repute, they should be able to admit you to pursue the professional course. with them.
Honorable, thank you so much.
It's my pleasure.
We've gone beyond time today, and I want to thank you because it's an important issue. Obviously, the interest that has been shown in
we may have to find another time to.
Obviously, and that is one that we'll bet on, and I know that you make some time to join us again for a lengthy discussion on this. But today, this is what happened. So, a number of you, some of the questions you've sent, we have asked, and trust that we would come back to this conversation. We'll have a lengthy conversation on it as well, if not on Ghana Tonight, on a number of our programs on TV3. So watch out for that. But thank you. Honorable Nelson Roxon Dapemepo is the Member of Parliament for the South Dai constituency. He is the Majority Chief Whip and also one of the major proponents of this bill, the Legal Education Reforms Bill that has been passed now by Parliament. On behalf of the rest of the team, I want to say thank you for staying with us here on Ghana Tonight. We're back again tomorrow. I'm Alfred Okansi. Have a good night.
Ghana Tonight is brought to you by Flamingo Paint. Superior durability, superior hiding, superior coverage, simply superior.
Sasso insecticide spray and quell. Kumin tuntum prekun.